Welcome back to this third segment of this law session on the structure of government and Parliament as it currently stands. And in this third segment, we will focus on the House of Commons, and in the next segment, of course, we'll conclude with the House of Lords. Well, when we look at the House of Commons, you see that the framework is typical of most Commonwealth countries in that there's a bicameral chamber, in that you have the House of Commons. In some countries it's called the House of Representatives, but the House of Commons, here we have the government in there, as we say, the cabinet, and what it comprises of course, is 650 elected members of Parliament. Now, each MP represents one electoral area or constituency. Now, under the Parliamentary Voting System and Constituencies Act of 2011, the number of seats in the House of Commons is to be reduced over time. And the idea is that by 2015, it should hit no more than 600. Now, general elections, which of course determine the political composition of the Commons, must be held at least every 5 years. We see this starting, of course, in the Parliament Act 1911, and we've now seen that embodied in the Fixed Term Parliament Act of 2011. Now, after a general election, it is the leader of the political party that has won the majority of seats in Parliament who automatically becomes the Prime Minister and is, of course, formally appointed by the Crown. If it is that no political party wins a majority of the seats, then the party with the largest number of seats may negotiate with other political parties to form a coalition government. And this, of course, is what happened in 2010. Now, the current makeup of the Parliament in England is that there are 303 Conservative MPs. You have 57 Liberal Democrat MPs, and of course you have Her Majesty's opposition, which is the Labour Party, with 252. Now, there are other what is termed other opposition, and this includes various. It could be the Plaid Cymru Party, the Alliance Party, the Green Party, Independent, the SNP, the DUP, Sinn Féin. And one of the things I would certainly suggest you research is look at the issue with Sinn Féin and the idea of abstention. We see that there are 5 seats that Sinn Féin has in the House, but what we'll see is that they never turn up. You ought to have a look at that because it is an interesting conundrum within the whole framework of the parliamentary setup in England and Wales. Now, the opposition is formally referred to as Her Majesty's Loyal Opposition. And what the opposition is there for is to challenge the government of the day and to ensure that it is accountable to the people through Parliament. Now, the opposition party is structured in a similar way as the government. It has its own inner core of members, which has a correlation to the cabinet ministers in that they have shadow ministers. The opposition acts as a government in waiting, and the government of the day, the ruling government, can only continue in office so long as it has the support of the House of Commons. Now, if the government loses parliamentary support, for example, it loses a vote of confidence, then the opposition may force the government out of office, and a general election will of course take place to determine who the next holder of government office is. Now, what we see under the Fixed Term Parliaments Act is that it provides for a fixed period for elections, but there are 2 exceptions, not least when we see a vote of confidence issue coming about, or indeed if Parliament agrees as it were, among themselves. Now, we see that there are certain time periods as well allocated to the opposition. So they do have days within the parliamentary session which they can actually drive and dictate the subject matter for debate. Now, within the House of Commons, you have a speaker. The idea of the Speaker of the House of Commons is that he's an elected member of Parliament who, once he's elected to the office of Speaker, he basically throws off the cloak of allegiance to his own political party, and he's supposed to act neutrally, and his role is to chair the proceedings in the House. And the Speaker's role, of course, is to control debates, he controls the rules on procedure, and generally it is also for the Speaker to engage the disciplinary powers. In some countries, you will find that the Speaker tends to be, for example, someone from the opposition party. Now, there's a whole kind of traditional thing with the Speaker being dragged forward with some reluctance, because the idea is that he stands neutral to everyone in the House. Within the UK framework as well, when you look at Parliament, there are the whips. And each political party has certain procedures for ensuring that their members turn up, that their members vote, and so on. Now, interestingly, in recent times, we've seen the MP for Mid Bedfordshire, Nadine Dorries, going off to Australia and taking part in this I'm a Celebrity, Get Me Out of Here. Now, when you consider that, of course, she's down in Australia, what happens if there's a vote on something important? Well, the point of the whips is to ensure that members of Parliament are present to vote in support of or in opposition to whatever business is laid out before the government. Because what you have is parliamentary papers for the forthcoming week being issued, and it indicates when members are supposed to be available. And the most stringent that it can be is where, for example, you have what is called a 3-line whip. And here it indicates that an MP must be present for this kind of vote. And indeed, if you fail to attend, it may actually result in disciplinary proceedings. Now, please bear in mind that the whips are no more than agents of their respective parties, and they are not certainly agents of the party. Now, within the Commons, you have the parliamentary session usually running from about the autumn, somewhere in the November, to about the following October. And the idea is that there's a state opening with the Queen delivering the Queen's speech, which then outlines the government's policies and any kind of legislative proposals which are going to be coming forward in the next session. Now, the majority of government bills, of course, will be presented and laid out, and the idea is that they ought to be made into law by the end of the session. Now, when you look at the business of Parliament, the primary business of Parliament, of course, is to legislate. And when you look at an Act of Parliament or a statute, within the UK, it is the highest form of law. Now, the general rule or the general process is that you have a bill passing through the House of Commons in order to become an act. Now, I'll only focus on public bills, and that really is about government bills. It's not, as some people might think, oh, it's from a member of the public, as it were. That's not what it means. There are several types of bills, each with its own procedure, but the main focus that we will look at here is the public bills and the stages of a public bill, as it were. Now, the main business is legislating, having a bill go through, which then turns into law. And it starts off from a pre-legislative standpoint where you have consultation, and you will read variously about the white paper and the green paper. And the idea is that stakeholders and other persons, interested parties, it goes out there to see sometimes what is the view, what is the climate. But what we get nonetheless is we come to the point where you get a formulated bill, and you get this scrutiny of the bill, and usually a joint committee of both houses will review a bill and vote on any amendments that the government can either accept or reject. Now, the report here can generally be influential. And when you look at a bill passing through Parliament, it has various paths that it follows. It goes through a first reading, second reading, committee stage, it goes through the report stage. Now, the first reading is simply a formality. Generally, there's no voting, it's simply presenting. By about the second reading, you get somewhat a debate on the general principles of the bill, and after that, it is followed by a vote. By the time it goes to a committee, now, if you imagine you've got 650 MPs, not everything is going to, of course, come before them. So what you get are committees of somewhere between 60 and 50 approximately, who will, of course, look at bills and consider each clause in the bill, and they may, of course, make amendments. It then, of course, goes to a report stage, and at this point, the bill consideration is taken or reported on, and this usually takes place on the floor of the House, and it is a further opportunity to amend a bill. Now, unlike the committee stage where it scrutinizes it, at this stage, the House of Commons need not consider every clause of the bill. It need only focus on the amendments which have been tabled to be considered. It then goes to a third reading, and of course it then moves on to the House of Lords. And the idea is that it similarly goes through a process through the House of Lords, and of course it then receives the royal assent, assuming it goes through a similar process of first reading and so on. Now, a bill, of course, can originate in the House of Lords as well. The idea is that the House of Lords is an appointed house, and so they may put forward or initiate legislation that may not necessarily be politically popular, but still needs to be addressed. And so it may very well be that they take that position. Now, you have the Acts of Parliament, which has to go through that process. But then, of course, delegated legislation is an area that is certainly examinable. You'll never get an examination question that says, explain the process a bill takes, for example. You certainly might get one that says, when you look at the way a bill comes about, which is the dynamic interplay between the House of Commons and the House of Lords, especially when the House of Commons does not need the House of Lords in particular circumstances to pass a law, you may need to discuss something like that. But one other area that may be examinable is delegated legislation. Now, you're not going to have, or Parliament will certainly not have the time, resources, ability to make laws for every single thing. So you may have a situation where you have an act called a Parent Act, it's also called an Enabling Act, which allows for power to be given to, say, a minister or some other executive body in order to pass laws. Now, the Enabling Act or the Parent Act allows, let's say, for example, you have a fictitious municipality, and you have a Parent Act that says powers given to that municipality to deal with, for example, how they deal with roads and highways within that municipality. Well, it may be best left to them to deal with. And as such, delegated legislation, an act may then give that municipality the ability to make delegated legislation. Delegated legislation then can take various forms. It can be orders in council, it can be regulations, it can be rules, it can be bylaws, it can be rules of courts, it can be codes. But these are where, codes of practice, but these are where, for example, a minister has the power to make certain rules which have the force of law. So, for example, in England, when you look at the highway code, everybody who is to drive a vehicle in England needs to have passed their driving test. The driving test is based on the highway code, but the highway code is not a law. Rather, it is where, under the minister's remit, they've managed to make this code that allows for that. So the idea is that this is delegated legislation. The interesting thing about delegated legislation, of course, is that you cannot challenge an act of parliament, but you can challenge delegated legislation. So if it is that a minister has made legislation, for example, delegated legislation, which takes him beyond the boundaries of his remit that is allowed within the Parent Act, then it may very well be that that can be challenged. You can't challenge the Act of Parliament, but you could challenge delegated legislation, especially if, for all intents and purposes, it is ultra vires, meaning that he's acted outside of his powers. If that is the case, then unfortunately, you could, of course, seek judicial review. Now, the government of the day is scrutinized, and there are various aspects of scrutiny, not least when you look at question time or certain types of debates or early day motions. Parliament can ensure that the executive is doing what it is supposed to be doing by engaging certain scrutiny actions. And in this way, we see that it keeps it in checks and balances. Now, in 2010, the House of Commons voted to change the system of appointing chairs of select committees, and they are directly elected by MPs rather than by party whips. Now, I want to end, of course, on, this segment on the fact that you must consider the interplay between the House of Lords and the House of Commons. We're going to take a short break, and as we come back, we certainly will start off with looking at where we see the House of Commons leaving off and moving into the House of Lords, and we will also examine the whole context of House of Lords reform.